Hello and welcome to the Wake Up Call podcast. Today we're speaking with Dr. Kevin Gutzman about the natural-born citizenship controversy and the legacy of the late Justice Antonin Scalia. Dr. Gutzman is the chairman of the Department of History at Western Connecticut State University and the author of the New York Times bestseller, The Politically Incorrect Guide to the Constitution, as well as James Madison and the Making of America. He has a law degree from the University of Texas at Austin and a PhD in U.S. history from the University of Virginia. You can follow his work at kevingutzman.com, that's KEVINGUTZMAN.com, or on Facebook and at Kevin Gutzman on Twitter, as well as through his courses at libertyclassroom.com. For more information, see the show notes page for this episode at wakeupcallpodcast.com/Scalia. Dr. Gutzman, welcome to the show.
Happy to be here.
So let's start off with the simple, basic question. What is the natural-born citizen clause in the U.S. Constitution, and why is there a controversy surrounding its meaning?
Well, first is the easier question. The natural-born citizenship requirement is one of the requirements, one of the qualifications of a president. One must be a natural-born citizen, have attained the age of 35 years, and have lived in the United States for the previous 14 years. Why is it controversial? Well, because lawyers can argue about anything, and when there's a major presidential candidate who doesn't meet the qualification or doesn't satisfy the qualification, there are going to be attorneys who can argue that he does. So the short version is that we have a major presidential candidate who's not a natural-born citizen, and people predictably argue that he is.
All right, so we'll get into some of the individual candidates and their eligibility in a moment, but can you talk about what the founders meant when they wrote this clause and some of the antecedents to the Constitution that might help us in understanding what this clause actually means?
Well, sure. In the Philadelphia Convention that wrote the Constitution itself, there's no recorded discussion of the term natural-born citizen. However, it's most common when people want to know the meanings of common law terms that are found in the Constitution and don't find any discussion of them in the Philadelphia Convention or in the ratification materials, that they turn to either Sir William Blackstone's commentaries on the laws of England, or in matters like this one, in regard to matters like qualification for citizenship, to Emmerich de Vattel's Law of Nations. Both Vattel's Law of Nations and Blackstone's commentaries on the laws of England define the term natural-born citizen in such a way as to leave Cruz out. That is, Senator Ted Cruz of Texas, who's a Republican candidate, out of the category of natural-born citizens. So I think the onus is on people who advocate his candidacy to show why our usual habit of relying on Blackstone and Vattel is mistaken in this case, and they have not done so. What they have done instead is provide us a lot of uncharacteristic references to court cases from 1880 and 1904 and statutes adopted by Congress and so on. And in other words, rather than acting like originalists, which is certainly what Senator Cruz claims to be and what most of his supporters say that they are acting like Brennanites, like judicial liberals. So it's somewhat pathetic, really. And, I think it's, on the other hand, predictable. As I said before, you can find a lawyer to argue almost any political point. So we maybe shouldn't be totally surprised that friends of Senator Cruz are arguing that he's a natural-born citizen.
How do you think a ruling on this clause is going to come about? And do you think there's going to be a ruling on this?
Well, I don't think there will be a ruling, or if there is a ruling, I don't think it'll be a correct ruling. And the reason is that by now we have a long history of naturalization that would allow people born abroad to American parents to claim citizenship. And Senator Cruz was born abroad to an American parent. However, Interestingly, I understand that if one is born abroad, one must file a particular form within a certain span of time with the State Department. And as I understand it, when people asked Senator Cruz's campaign please to produce this form that had been filed by his mother in Canada, they said no, they wouldn't produce it. So one can't really come up, I think, with a lot of reasons why they wouldn't produce such a form if there were one. And it seems that the obvious explanation is that there isn't one. That leaves open the possibility that not only is Ted Cruz not a natural-born citizen, maybe he's not even legally a citizen at all. So I think that's somewhat ironic, but in any event, that, of course, that isn't directly related to his qualifications for president. That would have to do with his qualifications to be a senator from Texas.
Now, in addition to the controversy surrounding Cruz, we've also seen a controversy around Marco Rubio to a smaller degree, who was born in Florida, but neither of his parents were citizens at the time. And then we also saw a controversy around Obama, because I guess his dad wasn't a citizen when he was born, and around John McCain, since he was born in the Panama Canal Zone. So are any of them, well, I suppose McCain and Obama are done running for president, but would any of them have eligibility issues if this clause were interpreted the way it should be?
Well, the issue is how it should be, and again, Senator Cruz and his supporters usually claim that they're originalists. An originalist is somebody who thinks that the Constitution should be read as it would have been read by the people who ratified it, that is, the people who adopted it in 1787 to 1790 when it was being adopted, that is, when the states were agreeing to live under it. There is essentially no argument you can make from materials from the ratification period or before that says that Ted Cruz is a natural-born citizen. There's no authority for the idea that somebody born out of the United States is a natural-born citizen. Now, under the common law, there was an exception to the general rule that one must have been born in the country to be a natural-born citizen for people whose fathers were ambassadors posted abroad. So if you were an English ambassador's son who happened to have been born in France when your father was stationed in France, the common law said that, that is a statutory law, I should say, said that this was an exception to the general rule. But of course, Ted Cruz isn't the son of an ambassador. In fact, his father at the time of his birth was an alien. So that exception clearly doesn't apply to him. I think Senator John McCain was born outside the country as well. And in fact, is commonly known among people who were, it was kind of a joke among people who were Army brats. When I was a kid, I'm an Army brat, and McCain was a Navy brat, that, well, if you were born abroad, you weren't eligible to be president. So I think Senator McCain wasn't eligible to be president, being born in the Panama Canal Zone, where, as it happens, I lived for 3 years in the 1970s, was not being born in the United States. So, well, of course, the political elite allowed Senator McCain to be a candidate, and this didn't really become a controversy, although in 2008, I actually told people that I thought he was ineligible because he'd been born in the Canal Zone. It happens, actually, that Senator McCain was born on the base where I went to fourth grade. So that is the kind of example that Cruz supporters are pointing to now. But again, the problem is Cruz supporters claim to be originalists. So even if Senator McCain, the example were an example of the law having been correctly applied, it's not originalism to say I'm relying on a precedent from 2008 or a court case from 1904 or 1880 or a congressional statute passed in 1790. None of this has anything to do with, it might give us some inkling of, but it doesn't really tell us what people thought the Constitution meant when they were ratifying it. So as for Obama, he was born in the United States to a citizen parent, and this, as I understand Blackstone's definition, makes him a natural-born citizen. Rubio, on the other hand, is an interesting question because We have, of course, the Citizenship Clause of the 14th Amendment that says that anybody born in the United States is a citizen of the United States and of the state in which he resides. And you might think, well, why is it that there is this provision? And the answer is because the Supreme Court, the 14th Amendment was ratified in 1868. The Supreme Court in 1857 had made a gigantic exception to the general rule about citizenship that I've just been describing in the case of black people. The court said in the Dred Scott decision in 1857 that if you were black, it didn't matter whether you'd been born free, whether your parents were free, what their status was. A black person could not be a citizen of the United States. So the reason we have the Citizenship Clause of the 14th Amendment is to negate Dred Scott's holding about black people. But that did not have anything, and actually, besides that, it's interestingly the case that the chief Senate sponsor of the 14th Amendment told the Senate, as the 14th Amendment was being considered in Congress, that, well, of course, the Citizenship Clause does not apply to foreigners. Those are his words. Of course, the Citizenship Clause does not apply to foreigners. Well, Marco Rubio's parents were both foreigners. When he was born, that means he was a foreigner in the United States, and this flat statement that he might rely on, that somebody who's born in the United States is a citizen of the United States in the state in which he resides, doesn't apply to him. However, the common law definition of a natural-born citizen is somebody who's born in the king's dominions. So if you were Rubio and you're born here legally, you were a natural-born citizen according to the common law. Patel, on the other hand, is an interesting issue because, of course, Patel originally, he was Swiss and he wrote in French, and there's some question about which translations were available when in the United States, but my understanding is that the earlier translation was from 1756, I think, so there actually was a translation of Patel available in the United States by 1787 when the Constitution was written, and thereafter, of course, when it was ratified. And it said that a natural-born citizen was somebody who's born in the country of citizen parents. So in that case, Rubio would not qualify as a natural-born citizen, even though under Blackston's common law definition he would. I think that the better authority is always Blackston for common law terms. So I would say Rubio is a natural-born citizen as originally as understood at the time of the framing and ratification of the Constitution, while Cruz clearly isn't.
Very interesting. So let's pivot a little bit now onto Scalia. So the late Justice Scalia, who was he and what was his career like before he joined the Supreme Court?
Antonin Scalia was the single brightest star in the Reaganite judicial revolution. So in other words, when President Ronald Reagan was elected in 1980, we had a totally different constitutional culture from the one we have today. And the chief reason for that is Antonin Scalia, although, of course, the overarching program was Ronald Reagan's program, and it was mainly his second Attorney General, Edwin Meese, who implemented the program by going out and advocating what Meese, in a famous speech in the mid-1980s, called the jurisprudence of original intent, and then choosing people to be federal judges, not only on the Supreme Court, but on the lower courts as well, who are going to rule or are going to implement this jurisprudence of original intent. So there had come to be a kind of consensus among conservatives during the Reagan administration that this is the way the Constitution should be read, as I mentioned earlier, according to the way that the people understood it when they were agreeing to live under it during the ratification process. If you think about it, it seems that it's just incontestable that this is the way that the Constitution ought to be read. After all, the chief American political science conceit is that we believe in government by the consent of the governed. Well, what does government by the consent of the governed mean? I think in the first place it means that the government is the one we agreed to. And the government that we agreed to is the one we understood that we were agreeing to. So if you ask, well, how is the Constitution supposed to be read? It should be read as people thought it was going to be read because, again, that's what government by consent of the governed means. And in fact, this way of reading legal documents is non-controversial in other areas of law. So if, for example, one goes into probate court, the question the judge is supposed to concern himself with is what lawyers call the intent of the testator. That is the intention of the deceased who's left this will to be implemented in the probate court. If the issue is a contract, then the question is, well, the first thing is, did the parties have a meeting of the minds? That is, did they agree about what this contract meant? And if they did, well, what did they think it meant? Similarly, if the issue is implementation of a treaty between two countries, if either country attaches a codicil to the treaty and says, well, here's how we interpret what might otherwise be considered murky language in Section 2 or in Article 4 or in any other way clarifying it, that is going to be binding on the other parties to the treaty. It's only when it comes to the American Constitution that we have some people who argue, well, no, it doesn't matter what the people thought they were agreeing to when they ratified the Constitution. Because, and this is one of their common weasel terms, really we have to concern ourselves with, quote, the evolving standards of decency of a maturing society, right? So it's always the case for people who say things like that the evolving standards of decency of a maturing society lead to exactly the policy outcome the particular person saying that prefers. So anytime somebody says, well, I don't like the originalist idea, I prefer to rely on the evolving standards of decency of a maturing society, what he's really saying is, yeah, I know what the Constitution meant to the people who adopted it, but I have a better idea. I'm more decent. We've evolved, and the ultimate product of evolution is me, the judge. So this idea appalled me. It actually appalled a lot of people. You could argue powerfully that one of the main reasons that Richard Nixon was elected president twice and one of the main reasons Ronald Reagan was elected president twice was that so many people were appalled with the behavior of the federal judiciary, whether it was in creating various kinds of expression rights or whether it was shielding people from various kinds of criminal penalties or whether it was forcing millions of kids to ride buses across town every day in order to achieve some kind of racial program, or any of numerous other programs that the federal courts have decided they were going to foist off upon the country despite evident absence of support for those programs in the Constitution. So, as I said, Meese, the second Attorney General under Reagan, gave this famous speech, and I think it was in New Orleans in 1985, maybe it was in 1986, and he said the title of the speech was Toward a Jurisprudence of Original Intent. The idea there was we need to get away from all this legislative behavior by judges and get back to the idea that the judges should be enforcing the law that the Congress thought it was adopting and the president thought he was agreeing to when he signed it, not just whatever they thought was decent or preferable, in other words, at the time that the case came before them. Scalia, before he became a Supreme Court justice, graduated from Harvard Law School and been a professor in the University of Virginia Law School, which I'm partisan of because I have my PhD from UVA. But actually, Virginia is one of the 2 or 3 best public law schools in the country. I say that as a graduate of another one of them. So he was a prominent person in legal academia, but he was a young fellow. He actually had been also in a presidential administration, the Office of Legal Counsel in the White House, and early on in the Reagan years, he was appointed to a lower federal court, and finally, when the Chief Justice Warren Burger, who had been a Nixon appointee and kind of moderately conservative fellow without any clear philosophical commitments, when he retired, President Reagan moved Associate Justice William Rehnquist over into his slot and then put Scalia in Rehnquist's old slot so that essentially what you're going to have was I think the most Jeffersonian associate justice ever, Rehnquist, now as Chief Justice, and then Scalia taking Rehnquist's seat as an associate justice on the court. So Scalia ended up one other thing that Scalia did before he became a justice was he was one of the people responsible for the founding of an organization called the Federalist Society for Law and Public Policy. And the Federalist Society had the function, and still has the function essentially, of providing an alternative in American law schools to the standard issue liberalism that is kind of beaten into the heads of law students on a regular basis. I know for example, I'm alluded to this before, but I'm a graduate of the University of Texas Law School, which is one of the, again, like UVA, one of the best public law schools in the country. And when I was in law school in 1987 to 90, of course, there was the 1988 presidential election. My understanding is that out of the 43 people on the faculty, 42 of them had voted for Dukakis in that election. And, UT is considered a kind of conservative law school. But that, I think, is kind of the run-of-the-mill in American law schools. So, again, the function of the Federalist Society for Law and Public Policy, which, when it was founded, existed in 3 of the most prestigious law schools, was to bring in speakers, to bring in academics and other people who are prominent in the legal profession or in legal scholarship to present alternative, mainly conservative or libertarian takes on important legal and constitutional questions. This organization became, and lots of liberal scholars say this now too, it became really the chief source of intellectual ferment in legal academia. If you're a law student, you're unlikely to hear debate on important questions about the history of the Constitution or the history of particular statutes or the desirability or constitutionality of capital punishment or whatever, unless it's at a Federalist Society function. And Scalia really was one of the prime movers in establishing that organization. I said before, originally it was in the 3 of the most prestigious law schools, but now essentially there are Federalist Society functions and chapters in basically every American law school. So that is one of the most important legacies of Scalia. And along with the public statements of Mies and the jurisprudential contribution of Scalia, Clarence Thomas, Rehnquist, Alito, Roberts, these other conservatives have been appointed to high federal judicial positions. This organization really helped to change our entire constitutional culture. So nowadays, if you read books about constitutional history or about judicial politics or about important constitutional questions that are current, even the most liberal scholars like Akhil Amar at Yale and Cass Sunstein, formerly of the Obama administration, before that at the University of Chicago Law School and so on, if they're not going to end up there, they're going to start by talking about originalism, right? Well, the originalist position would be this, 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 and this. Here's why I disagree with it. That is the absolute opposite of the situation when Reagan was elected president, and Scalia was a prime mover in making that happen.
All right, so now let's look at, I guess, Scalia's consistency to the originalist philosophy, because it seems like sometimes he let his political preferences override his judicial philosophy. Can you go into that and his views on the Due Process Clause and the Commerce Clause and the Incorporation Doctrine and maybe some of these other areas where he was not fully committed to originalism?
Well, I can't recall the exact phrasing of it, but he, at one point within the last 5 or 10 years, he gave a public talk where he referred to himself as something like a timid originalist. In other words, he had decided, there are, maybe you don't know, but there are large bodies of constitutional law, which is to say of judicial precedent relating to the Constitution that are long established now and that have come to be relied on by the government and by the populace, which one cannot justify on an originalist basis. So you might say, in other words, if you were a heedless originalist, if you didn't mind the idea of making a revolution by undoing, I could argue that 90% of the line items in the federal budget are unconstitutional. If you didn't want to make a revolution by just undoing all of this, then you might find yourself in the same position as Scalia. So I think the way he tended to approach this issue of, not striking down statutes creating the EPA and the Department of Agriculture and Department of Education and NASA and Social Security and Medicare, and stop me when I'm, getting warm here. If he didn't want to say, well, we as a court are going to get rid of all these unconstitutional programs, and virtually all of them are unconstitutional, what we'd have to do is, as one other prominent originalist, Robert Bork, once put it, well, just tell the Congress, go and sin no more. In other words, don't give us anything new. So Scalia, I think, sometimes used that as a kind of cover for his policy preferences, but I think in general his attitude was, well, on one hand he's an originalist, on the other hand he's conservative. So he's not going to want to have the federal courts, as I say, completely remaking the federal government. By the way, I'm not justifying this. I tend to be a little less timid than he, but on the other hand, I'm not in a position of authority where my opinion actually matters. So I don't know exactly how I would take. I mean, there are other governmental questions where one can take a philosophical position, but then one can kind of think, what if I were actually responsible? I know, for example, my own case, capital punishment works that way for me. On one hand, I think it's philosophically justifiable. In fact, you might even say it's incumbent on the government to execute murderers. It's only just to the people who've been killed, one could argue. But on the other hand, would I want to be the person signing the warrant or flipping the switch? Or I don't know. I don't know that I could do that. I don't know that I would find that I had the courage of my conviction in that case. And so the idea that the Supreme Court was going to be getting rid of Medicare one day, just out of the blue, announcing Medicare is unconstitutional, it can't exist, it strikes me as profoundly non-conservative, and so Scalia wasn't prone to do something like that. On the other hand, he did, as you intimated, as you suggested, he did exploit some of the unoriginalist presidents of the Supreme Court to create new rights, for example, under the incorporation doctrine. I think that's lamentable. He shouldn't have done that. It's really inconsistent with his claims about his views about the Constitution and the role of judges. So that, I think, is the main weak point of his record.
Yeah, to follow up on that, can you talk about Johnson v. Texas and Employment Division v. Smith, and how his positions on those cases conflicted with originalism?
Well, sure. Johnson v. Texas is interesting to me, partly because I had connection to two people who were involved in it. The fellow who represented Johnson in his appeals was my law school civil procedure professor, Mike Tiger, and the attorney who wrote the Supreme Court, the Texas Court of Criminal Appeals opinion in that case, was at the time married to the Austin lawyer for whom I was working as a legal clerk. So I talked to her about this actually after she wrote that opinion, and then when the court adopted that opinion as its opinion, as when the Texas Court of Criminal Appeals adopted the opinion she'd written as its opinion, she resigned her position and decided she didn't want to be involved in doing this. She hadn't liked the outcome, and she hadn't thought it was justified, but she had written this best argument for it. So essentially what happened in Johnson was that in 1984, the Republican National Convention was in Dallas, and so a local communist named Johnson down the street from the convention center stole a flag from a business's flagpole and then carried it down the street and burned it. And he got in front of the convention center. And so he was arrested by Dallas police and tried under the Texas, I think it was actually maybe the Dallas ordinance, banning burning the American flag. And ultimately, the case went to the Supreme Court, where Scalia, of course, relying on the incorporation doctrine, that is, relying on the argument that the 14th Amendment due process clause makes the free speech clause of the First Amendment applicable against state governments. Of course, is nonsense, but that's what it says. That's what the incorporation doctrine says. Scalia, relying on that incorporation doctrine, wrote the majority opinion for a closely divided court, saying that, well, burning a flag is speech, which, you know, I think my kid, when she was probably 3, could have told you that burning a flag isn't speech, but he held that burning a flag is speech, and so Texas and the other states, virtually all of them, and besides the federal government, that have bans on this behavior, can no longer enforce their bans on this behavior. That's actually been the grist of a lot of political disputation since. And Scalia asked on one occasion about this kind of issue. This was also a big deal when it came to criminal procedure and criminal punishments and so on. Said, well, you know, we're not going to recite the incorporation doctrine. And that's clearly a non-original statement. So I said before, I think that's lamentable. The employment division case, what happened there was not about the incorporation doctrine, although it was an incorporation. It was because of the incorporation doctrine that the case was in federal court. But really what the case was about was the free exercise clause idea in general. And what had happened there was that a couple of guys, I think they were in Oregon, right? They were members of what was called the Native American Church. And the Native American Church rite included ingestion of peyote. And so, of course, predictably, the state authorities arrested these two guys and they were convicted of having used peyote, which they didn't deny. But their argument was, well, this is part of our religion. We have to use peyote. And ultimately, Scalia, for the majority of the court, said, well, where you have a facially neutral statute and it trounces on people's exercise of their religion, that's not unconstitutional. What the free exercise clause prohibits are federal or state policies intentionally curtailing people's practice or infringing upon people's practice of their religions. So this was very controversial and somewhat surprising, actually. People who've been paying attention in the last few weeks have noted that Justice Scalia's funeral mass was led by his son, who's a priest, and actually his son gave a very widely circulated homily at the funeral. And apparently Scalia was himself a pious Catholic. And actually a friend of mine, whom I was not aware was acquainted with Scalia, posted on social media a story of having encountered Scalia one time where it wasn't known to Scalia that my friend was present watching this, but the three of them were in a large church in Washington, D.C., and when the Mass ended, Scalia encountered a woman who was agitated, apparently had not, must have been living in the streets. She apparently hadn't been clean in quite a while. She had sores on her face and on her hands and so on. And Scalia apparently went over to this woman and she was talking loudly to him about something that had nothing to do with anything. And he took her by the hand. He put his one hand around her neck and, was holding her close to himself and gave some kind of donation to her and tried to kind of talk her down out of her agitated state and so on. And my friend's conclusion was, well, this was an episode in which the justice didn't know that anyone was watching, and that must just have been the way he acted. So the point is that besides that, he was a Catholic. Not only was son a priest, he had 9 kids, he had 40 grandkids. You get every kind of evidence of being really a pious person. So people were surprised that he was the author of this opinion. In fact, there was a lot of political controversy over it, and ultimately Congress passed a statute called the Religious Freedom Restoration Act, whose purpose was to, quote-unquote, correct the opinion of the court. Well, of course, later when the court had a chance to held that the Religious Freedom Restoration Act was unconstitutional, but that opinion from Scalia, I think, reflected, and I'm not usually critical of it. In general, I think he was an excellent justice, but I think it reflected just too little attention to our tradition of conceding that people are going to have odd religious, that is, unusual religious practices, and one of our chief commitments is that we're going to tolerate where they're tolerable people's unusual religious practices. So that, I think, is one of the most important of Scalia's mistaken or maybe wrong-headed opinions. Of course, we don't know exactly what kind of thought process he went through in getting to that conclusion. So who knows what it might have been like to discuss it with him. But I think, without knowing, that he was wrong in that case.
So one more aspect of his philosophy I quickly want to ask you about before we talk about what will come next and we conclude this interview. But that's his view of the Commerce Clause, in particular, how he articulated that view in the partial birth abortion case. Can you talk about that a little bit?
Oh, well, it's an interesting issue. He and Justice Clarence Thomas both concurred in the court's decision striking down the partial birth abortion. Upholding the partial birth abortion ban. So, back a few years, Congress passed a statute banning a procedure that's called partial birth abortion, that involves exposing part of an unborn child's body through the birth canal, and then when the very last bit of it is still within the mother's body, dispatching the child in a very gruesome way. So Congress passed a statute banning this particular procedure. You might think that Congress really had no authority to be banning this procedure. I think by any originalist reading, the ground that Congress cited in the statute, which was the Commerce Clause, is not apposite. In fact, relying on the Commerce Clause for this kind of claim of authority by Congress really is a tactic that goes back most classically to the New Deal era. When in 1937, we basically got away from the court enforcing limits on congressional authority and went into the new era we've lived in ever since, in which Congress essentially will defer to, in which the courts essentially will defer to congressional claims of legislative power. Well, what Scalia and Thomas said in concurring in the opinion or in the decision striking down the upholding the partial birth abortion ban, was, well, in general, we don't like the current jurisprudence of the court when it comes to the Commerce Clause. In general, we don't think that the Commerce Clause was kind of roving grant of power to Congress to pass any statute that one might say was related to commerce, or that affected something that one might say was related to commerce. We think that that's far too broad a description of the power that the Commerce Clause was intended to give to Congress, but, said Scalia and Thomas, so long as that is the court's position, then obviously Congress has power to adopt a ban on partial birth abortion. So, in other words, they were saying they thought that the partial birth abortion ban was unconstitutional, but so long as the Supreme Court was going to hold various other kinds of congressional enactments constitutional under this incorrect reading of the Commerce Clause, Scalia and Thomas were going to go to uphold this exercise of unconstitutional authority by Congress on the basis of the same mistaken reading of the Commerce Clause. That was, I think, probably intended to be a cute concurrence, right? This was kind of a finger in the eye of the other justices who were apoplectic over Congress's daring to do this, and then the five justice majority upholding it.
So, where does this leave the court now? How does it work only having 8 justices, and what should we expect moving forward?
Well, first, how does it work having only 8 justices? I think there's basically no problem having only 8 justices. In fact, the judicial system would work just fine if tomorrow a bomb blew up in the Supreme Court building and we were left with no justices for a while. Seriously, it's not going to put any kind of brake on the performance of the lower courts. It's not going to keep Congress from legislating. It's not true that legal cases can't be decided if we don't have an odd number of justices. In fact, there have been 2 periods in American history when Congress adopted legislation saying there should be even numbered of justices. The original statute organizing the federal courts, the Judiciary Act of 1789, whose chief authors were Oliver Ellsworth of Connecticut, later Chief Justice, and William Patterson of New Jersey, provided there should be 6 justices. So the Jay Court, the Ellsworth Court, when Rutledge was Chief Justice, there were 6 justices. Similarly, in the 1860s, we had a period when there were 10 justices, and nobody thought this was a problem, and it wasn't a problem. What happens is that in case there's a tie vote on the court, then the holding in the Circuit Court of Appeals from which the case has been appealed to the Supreme Court will stand. So if we end up with 4-4 votes, that means the party that won below wins in the Supreme Court too. There's not, however, an opinion from the Supreme Court because there's not a majority, so basically the court doesn't establish a rule that's binding across the whole country, but there's this precedent from the lower court for that circuit. In other words, every case will still be decided. The other thing is, of course, people don't often realize this, but it is true. Every year there are thousands of appeals to the Supreme Court. The Supreme Court typically decides, in some recent years, it's fewer than 80 cases. So even if you appeal to the Supreme Court from a lower court, almost certainly the Supreme Court is not going to take your case. And then if it does take your case, it's possible to come back and say, yeah, we shouldn't have taken this case. So sometimes, in other words, they say, okay, come to oral argument, give us briefs. Lawyers write out their, 40-page arguments, and then they go argue for hours, and then the court says, yeah, we're sorry, we shouldn't have taken this case. So, and sometimes, too, they decide to uphold what the lower court has done without even giving any justification for it. That's actually a very common thing for the Supreme Court to do. So I think all the talk about how it's just the worst thing ever, and the court can't function, and life will cease to exist, and so on, if Scalia's seat isn't filled, yesterday, it's just gross exaggeration, and everybody who's saying that knows it.
Now, what do you expect moving forward, as far as the whole process of replacing Scalia and how that's going to play out?
Well, political prognostication is not really my forte, but I have been one who has long said, not only in Democratic administrations but also in Republican ones, that the posture of many senators is that they will generally defer to presidents in regard to appointments, whether to courts or to the cabinet or to whatever other position, is a mistaken position. Senators are supposed to exercise judgment in this area. So I think that it's been wrong for senators just to say, well, the president sent this attorney general nominee, or this guy's named to be a 3-star general instead of 2 stars, or I'm a Republican, so whichever Supreme Court appointee President Bush sends us, well, I'll generally tend to go with that. I think that was wrong. If currently we have a president and a Senate majority that are bitterly divided, I should think that the Senate majority would probably not accept his nomination, would probably not act in a positive way on the president's recommendation. And if they decide, as they apparently have decided, that they're just not going to accept any nomination from President Obama at all, there's nothing wrong with that. There's no requirement that the Senate act on the president's nomination. So I've heard people say recently, in fact, Glenn Eiffel on PBS said recently, this is the first time that anything like this has ever happened. This is the first time that the president's nominee is not going to get a hearing. Well, actually, it happened there was never a president's nominee who had a hearing until 1925. So not only is this not the first time, but for most of American history under the Constitution, nobody had a hearing. Nobody ever had a hearing. And then in 1925, when a justice had a hearing, it was because he requested it due to what looked as if it might be a scandal involving him. He wanted to go to the senators and explain that the scandal wasn't really a scandal. The idea that we have these routine dog and pony shows when there's a Supreme Court nomination, this is a relatively recent vintage. So I can remember, back in the 60s, 70s, I had kind of a glimmering of recollection of the mid-70s nomination of Justice Stevens, and that wasn't a big to-do. And, now sometimes we have days and days of nominees sitting before the Senate committee and hearing a lot of speeches and occasionally having a question to answer. There's nothing in the Constitution requiring that the Senate do that. And I could argue that it's a waste of time and really kind of cheapens everybody's office. So those are silly claims. They're partisan claims. They're what one expects from PBS. And so it seems to me that it's unsurprising that McConnell said we're not going to go forward on anybody President Obama nominates, and it's not surprising the Democrats say, well, you should. And I would hope, as speaking as somebody who agrees with Scalia about originalism, I would hope in light of President Obama's complete contempt for the idea of originalism, which I would also call his complete contempt for the idea of law, because that's what originalism is, I would hope that the Senate actually wouldn't go forward with a nomination from President Obama.
Okay. Well, I think that's all the time we have. Thank you so much for coming on the show. Where can our listeners find more of your work?
Well, I do have a website, kevingutzman.com, and I'm a faculty member at libertyclassroom.com. I also, every Thursday at 1 p.m. Eastern Time, have a 1-hour radio program on Veritas Radio Network, which is an online network, VERITAS Radio Network. My show is called The Constitution Hour, so people can tune into that too. Even after it runs live the first time at 1 p.m. Thursdays, it's on the website, Veritas Radio Network, so you can find all the past episodes there as well.
Oh, wow. I didn't realize you had that. Is that Mike Church's project?
Yes, it is.
Okay. All right. Well, I'll definitely listen in then, and I hope some of our listeners will as well. Well, on that note, I just want to remind everyone to go to wakeupcallpodcast.com/Scalia. We'll have links to all the resources you mentioned, and that is going to be the place to go for this episode. So thank you for being so generous with your time, and thank you for coming on the show today.
You're entirely welcome. I enjoyed it.
Thank you for listening to this episode of the Wake Up Call podcast.
If you would like to listen to more episodes, please subscribe, rate, and review the show on iTunes, or subscribe on Stitcher, and check out our website at wakeupcallpodcast.com.
There you will find show notes pages and comment sections dedicated to the show. You can also email us at contact@wakeupcallpodcast.com if you're interested in being interviewed for the show or have any other suggestions.
Thank you.